Hi, welcome back to the podcast, HOA Hell. I'm your host, Michael Kushner, and with me, as always, is co-host Sam Keel, Senior Associate from MBK Chapman. Sam, good morning.
Morning, Mike. Glad to be with you.
Glad you're here.
Thank you.
Sam, today, the topic we're doing was actually selected for us inadvertently by one of our listeners. As you know, because I told you, we get a lot of emails from listeners, and a lot of them come from YouTube, but some of them come from other avenues as well. This one came from YouTube. It was a really good question.
It is.
It was one I'd never been asked before, and yet this issue has come up more than once.
It really does. It comes up all the time in consults too.
And I didn't, and for some reason, it's just never been something that occurred to me to do an episode on. But when I read the question, I decided, you know what, I'm going to put time into the answer because I'm going to turn this into an episode and I'm going to write a fact sheet. Now, I've already written a fact sheet on this issue. You can go to the website, follow the directions that you're about to get, go to the website, go to the library tab, hit fact sheets, and you can either type in confidentiality or look for a more recent, one of my recent fact sheets that I did on this issue, okay? And basically what we're talking about today, as I said, came from this listener, and you can actually log into the HOA Hell YouTube channel and look for this question if you want to read it straight from the horse's mouth and then look at the response that I provided. But I'm going to, for the people that are listening to this, I'm going to read this question, and for those watching, it's going to appear on the screen. And here's the question that I received from this YouTube listener, completely unadulterated, unchanged. Here was the question. I privately contacted the board treasurer to share my concern that the manager was possibly embezzling and taking kickbacks. I attached documents supporting my concern. Instead of addressing my concern directly and or sharing it with board members, he immediately shared my email with the managers, who then went on a tangent during the next HOA meeting on how benevolent they are to our community. Is it not a breach of fiduciary duty to be sharing the private content of my direct email to the vendor manager that I am questioning? So today's topic is simply this. When is an HOA board actually required by law to keep a message from, or to keep things confidential? Let's put it that way, okay? Now this, as you just said a minute ago, this does actually come up constantly from two different avenues. One from neighbors complaining about other members, or members complaining about other members and saying, hey, I don't want this to get out, so keep this confidential. Or directors or members complaining about vendors or other directors or managers or a lawyer, whatever, for wrongdoing.
Right.
Okay? Now, many homeowners assume, and I understand the basis of the assumption, and I know that you do too, many homeowners assume that if they make a request for confidentiality, like I don't want to be seen as a snitch or whatever, that the HOA is obligated to honor that.
Right.
And that's a wrong assumption. That is incorrect, okay? Today, we're going to explain what the law actually requires. We're going to explain when confidentiality is mandatory on a board. But we're also going to delve into when it might not be mandatory, but it could be a breach of fiduciary duty. So in other words, the confidentiality isn't required for confidentiality's sake, but you must keep something confidential in order to honor your fiduciary duty.
Correct. So
we're going to talk about both scenarios. So we're going to introduce two separate scenarios. And I will label those as scenario 1 and scenario 2. So that should be pretty easy. Okay? One of the scenarios that I'm going to put into this was not part of this person's question. This person's question focused on that second scenario where, and I'll go ahead and give it away, confidentiality wasn't actually required by statute, okay, by the Davis-Stirling Act, for example. But it might have been a breach of fiduciary duty to disclose what was disclosed based on the question that the YouTuber asked me.
Exactly.
But I'm going to include in that scenario 1 a fact pattern that coincidentally came to us with a new client a day or two before I read that YouTube comment. And it is the first scenario, which is, was a complaint by one homeowner required to be kept confidential by the board, and the board's decision to not keep it or make it confidential. That's going to be our scenario 1. So it's funny that these two things came to my attention.
Yeah.
They're two sides of the same coin, and they are both exactly what this episode is about. Okay? Did I explain well enough what we're going to talk about today?
I think you've set the stage well. Once we delve into those scenarios, I think it'll make a lot more sense.
Okay, good.
Yeah.
And I will say that as a trigger warning for those of you who are animal lovers or pets, I am going to be describing kind of a disturbing incident where the homeowner in question, the bad guy, pepper sprayed without legal justification, pepper sprayed and injured one of our client's dogs. Okay. And so if that's a thing for you, you might want to tune out. Okay. When we get to that scenario. Okay. So let's talk about the core rule, and we'll start with confidentiality requirements. Okay. And that is, when is confidentiality required by statute? Let's start by saying that confidentiality itself is not the default in the law. It's actually the exception.
Correct.
And that should make sense to most of you. We've talked a lot in other episodes. We've talked a lot about how transparency, openness, Open Meeting Act, even the name of the act itself, the Sunshine Laws, those are all there to foster non-confidentiality, right?
That's exactly it. Yeah.
So confidentiality is the exception. So let's start with a governing principle. An HOA board is not required to keep member communications confidential unless a statute says they're required to keep something confidential. I'll say that again, more simply. There is no requirement for an HOA to keep a communication from a homeowner to them confidential unless a statute says these kinds of communications must be kept confidential. So you can bet we're going to talk about those statutes, okay? So that means that there's no general right to confidentiality, even if a homeowner asks for it, right? It might be discourteous or rude or off-putting to not honor a request, but a board's under no obligation. Today, we're talking about must, have to, and obligations, not should or woulda, but do I have to?
Right.
Do they have to? Are they required? That's what we're focusing on today. Confidentiality only exists in very narrow circumstances, and they're well-defined categories that are all in the Davis-Stirling Act, okay? And if a situation doesn't fall within one of those statutory narrow circumstances that we're going to talk about, then at least statutorily wise, there's no confidentiality obligation.
Right.
Of course, again, later we're going to talk about times when it might be fiduciary obligation.
Right.
Okay.
In other words, it's not mandatory pursuant to operative law, but the board within its discretion under extreme or exigent circumstances
Could
may
find
still
it-
exactly.
Could find itself in a fiduciary problem. Not always, but could. Whereas if you ignore a statutory, you are in trouble, okay, as a board member. So areas where the law requires confidentiality, narrow but prescribed, okay? California law does impose confidentiality obligations on HOA boards in certain circumstances. But like I said a minute ago, those are all clearly defined. There are three broad areas.
Yeah.
I'll start with the first one. You give me the next one. I'll finish with the third.
Sounds good.
First area, broadly speaking, is member discipline. So we're talking Civil Code Section 5850 and 5855.
Correct.
Okay? Both parts of the Davis-Stirling Act.
Discipline, fines.
Yes, exactly.
Yeah.
Discipline and fines. Member discipline and fines. You get a letter saying, come to a hearing, your trash cans are out too long, or you're violating our parking rules, or you are committing a nuisance, or you're whatever, violating some sort of, or you've put up trees that were not permissible, that are on our list of no-nos, right? And you put them up without permission, stuff like that, okay? Hearings regarding member discipline, or, and it doesn't just be hearings, issues related directly to member discipline are by statute confidential and to be maintained as confidential, okay? The same thing applies to disciplinary matters outside of hearings. Fines, records relating to discipline from the past, those are confidential. And does that mean they can never come out? No, there are situations, for example, in a court case, in discovery, it can come out, but these are required to be kept confidential in normal circumstances from other homeowners, okay? Confidentially applies to the hearing process. It applies to deliberations regarding discipline. It applies to outcome, notes taken and outcome of records. Again, those notes would be probably in the form of minutes in an executive session meeting, which would be confidential. And we'll talk about that in a minute, okay? But under the member discipline scenario, which is that first of the three examples we're going to talk about, it won't, confidentiality obligation doesn't extend to a member's report of a violation. So let's say it wasn't witnessed by a director, but it came to the attention of the directors from another member sending an email saying, hey, this guy's doing this or this neighbor's doing this.
Right.
That communication is not statutorily confidential, okay? Or homeowner complaint requesting enforcement. This person's constantly, not picking up their dog waste or da-da-da-da. Can you please do something about it? Okay?
Or eyewitness testimony in corroboration of a complaint.
Exactly.
For instance, too.
Exactly. Or any narrative sent to the board, okay, in the form of an accusatory narrative, which is one of the issues we'll talk about later in scenario one, okay? Those are enforcement inputs. They are not disciplinary proceedings, and they are not confidential.
Correct.
What's another one?
Well, the second category is pertaining to issues involving a member's financial information that is protected, including, let's say, things such as delinquency on assessments.
Right.
The failure to pay dues and then any enforcement action to be taken against them.
Is there a Davis-Stirling Act
There is.
section?
So the withholding there or the confidentiality would be proper pursuant to Civil Code Section 5215.
Okay. So we have assessment delinquencies, confidential. Okay. What else?
Well, it could be their payment history.
Exactly.
Could be anything bank-related, banking records and information. I mean, these are things that would in any form be privileged, confidential. If at any point they're produced, they'd be redacted, in any form. Other members are not entitled to receiving that. Even
what else?
Right.
Collection records. How about that?
Records, yeah. I mean, any form of enforcement, whether that's a pre-lien status or collection references. Now, there's a qualified reference to that can be made, let's say, merely to the property as by virtue of an APN reference. But beyond that, financial information,
Of course.
no.
Well, here's the thing. Look, you talked about a pre-lien notice.
Yeah.
Once it goes beyond pre-lien notice and it's actually a recorded lien, it's public record anyway.
Public record, yeah.
So at that point, the confidentiality goes away. Everybody knows, hey, they just recorded a lien against your property. And so at that point, confidentiality
But as far
is
as pre-lien notices, statutory compliance-related correspondence, let's say they're being reviewed or are engaged in negotiations involving, let's say, a payment plan. None of that is subject to disclosure or sharing with other members.
the homeowner that's facing those financial issues is allowed and rightfully expects complete confidentiality because it's required.
Exactly.
In other words, you don't get to financially shame somebody, for being in the poorhouse type deal. You don't get to do that.
Right.
Okay. If we're talking about board so far, if a director is guilty of releasing this information, that director actually could be held personally liable. There goes the business judgment rule.
There's serious
situation.
risk of exposure to personal
That's right.
of exposure to personal liability.
Right.
Yeah.
In cases where that has happened with our clients in the past, and legal action has stemmed from it because it was a bigger deal that was a big deal for whatever reason, we named directors personally.
Right.
Okay. So there is personal liability there. Directors, this is serious. It has teeth. You can't. You aren't allowed to share these things that are supposed to be confidential. You're not allowed to share them. If you do, when a homeowner wants to pursue it, you're in trouble, and rightfully so. Now the third category is executive session.
Yeah.
We've done a couple of episodes on executive session. I'm going to put a link for one of those up above if you want to kind of take a quick watch. And in that executive session episode that I'm linking to, we obviously talked about the operative statute, the Davis-Stirling Act, which is 4935. But I referenced the 5 categories. Now, I'm going to give a list of more than 5 things, and you might wonder, well, wait a minute, I thought there was 5 categories. Well, some of these fit into the same category. So I'm going to list, I'm trying to be over-inclusive, not under-inclusive. So there are 5 broad categories of issues that are appropriate to be discussed at executive session, but I'm going to list more than 5 things because I want you guys to get real-life examples of what we're talking about. So matters that are properly discussed in executive session, as opposed to those things that you're not supposed to discuss in executive session, matters that are properly discussed in executive session under Civil Code 4935, required to be kept confidential, okay? These include the mandatory 5 categories that we talk about in the episode that I just linked to a minute ago. But those 5 categories manifest in real life to a variety of different types of things. And let me just talk about some of them. Member discipline is one of those things that's discussed in executive session. Obviously, there's overlap here.
Yeah.
And that's okay. Member payment issues. So that member discipline, lapped over the first one.
Yeah.
And then this member payment issues is going to overlap with the second one that you raised.
I did, yeah.
Meetings with members regarding payment of assessments, kind of the second one again, right? Litigation. Pending litigation or contemplated litigation between the HOA and a member, or the HOA and a vendor, or the HOA and any third party. Okay, so in other words, if the HOA board is just contemplating litigation or talking about defending pending litigation, or there's been a threat, they can have that conversation off the record in executive session.
Including discussions of settlement, potentially.
All that. Anything related to litigation.
Right.
Okay?
Yeah.
Formation of contracts with third parties. Okay, so they want to discuss and debate whether or not the merits of a contract with a management company or with a landscaping company or somebody they're going to have come in and do the painting or re-roofing. Discussion of those contracts are required to be kept confidential, and that's properly discussed in executive session. Personnel matters, to the extent that your HOA is large enough to actually have employees, like a handyman that might be a full-time, or some large, really large HOAs have teams of people. Like they have built-in landscapers. They don't hire out to a third-party vendor. They just hire a landscaping team that's full-time. Okay, those would be personnel matters. Contract negotiations, and this can be any kind of contract. Okay, decisions on whether to take the next step beyond a lien notice and actually to
foreclosures,
foreclose. Right, exactly.
Yeah.
Or, that's a good example of pretty much everything. Those all fall within one of those 5 categories. When a matter falls into one of those, it's required to be confidential. That's it. Those are the 3 areas where, statutorily speaking, and we gave you the 3 statutes, confidentiality is required, and you face as a director personal liability for violating. Okay? So, let's now talk about the flip side, Sam. And that is, what does the law not legally require to be kept confidential? That is pretty much everything else in the world.
Yeah.
But let's talk about some real things so we can give examples. We could just move on and say anything that's not in that list doesn't have to be, but we're going to do better than that, okay? The following types of items are not required by California law, including anywhere in the Davis-Stirling Act, to be kept confidential, okay? I'll start, and you pop in a couple if you can think of any.
Okay.
Complaints about alleged rule violations.
Yeah.
Okay? We kind of hinted at that already, and that'll be our focus on scenario 1 when we get to the scenarios, okay? I think you have another one?
Let's say a member dispute, and this is kind of a bit of a crossover, but member dispute where it prompts reasonable inquiry by the board, where they have to go talk to, let's say, witnesses or things of that nature.
Very good.
Yeah.
Complaints about nuisances, right? Complaints about HOA vendors or managers. I was watching the landscaper and he was being just chopping away and blah, blah, blah. Or they're littering. They're leaving their, papers on my property when they're, trimming the sidewalk, and I don't want them doing that anymore. Or whatever it is. Those kinds of complaints about third-party vendors that work for the HOA as a whole, right? You have another one?
Instances where we have allegations made against, let's say, board members.
Well, it depends on the allegations.
Depends on the allegation. But there's some allegations that are not prejudicial to the complainant, and it prompts, let's say, an inquiry by the board. That is something that is to be shared. And if it's, let's say, if it's made like an open session meeting, for instance, right? Discussions of that, capturing that in a minute, I mean, that in itself is not something of a confidential nature.
Okay, fair enough. That's a really nuanced one. I would have avoided that only because it's going to be confusing for people. But if you guys can follow that, it's nuanced and it's accurate. We are going to talk about situations where the obligation to be confidential falls under a fiduciary duty, and it's based on accusations of directors or vendors, typically a director or a manager. But
when sent through private channels, however, once they are of a public nature,
exactly.
Yeah.
Okay, we'll get to those.
Yeah.
Just keep in mind that when it comes to complaints about director wrongdoing, there's a certain class of those kind of complaints that would have to be confidential for fiduciary reasons.
100%.
He's not talking about those. He's talking about, maybe a conflict of interest. I know that he's in the vote. I submitted my plans, and the minutes show that he voted on he's my neighbor and he's got an objection to my plans, but the minutes show that he voted to reject my plans, that was inappropriate. Something like that.
Did not abstain, did not refuse. Yeah.
No confidentiality obligation, something like that. Okay? That's what I think you were talking about.
Exactly.
Okay?
Yeah.
Keep in mind, and there's a good reason for that. If the board were required to keep the identity and contents of member complaints, for example, confidential, simply upon request, and enforcement would become a really difficult thing to do. Okay?
Yeah.
So let's talk about, let's hammer on that issue. The complaints from a member regarding wrongdoing by another member, whether it's a nuisance or violation of rules, and we're going to call that scenario one. Okay? In scenario one, in this first scenario, we're going to imagine a homeowner submits a lengthy complaint, email to the board, accusing another member, one of his neighbors, of misconduct and requesting in that email that the board keep both his complaint and his identity confidential. That is, do not share it. Now, this did happen in real life, and this he did also say to the extent that that's required by law or due process.
Exactly.
And that's great that he added that, but for my purposes, it didn't need to be added because, as you'll find out in a minute, I can spill the kitty, doesn't matter. The board can choose to ignore your request for confidentiality. Well, thanks for asking. We don't care. We're gonna disclose this and publish this. They could do that. Maybe not a good idea, maybe bad optics, but they can do it. Because remember, we're talking about have to today. Okay. So the board reviews the evidence. The accused homeowner they decide is actually in compliance, hasn't violated any rules. That is, the complainant's wrong. Okay? The allegations were not accurate and no discipline is warranted. The legal question there, and this was not the one I read at the beginning. This was one that came in a couple days earlier, coincidentally, was whether the confidentiality was required. We're not discussing whether it was preferable or whether the board could have or should have. We're talking about whether they had to keep it confidential. And they don't.
They don't. No.
That's the answer. Okay? There's no statute extending confidentiality in a complaint about another member. We just said that a minute ago. Or for a request to enforce. The point that I'm making here is that the mere request by a homeowner for confidentiality because it's uncomfortable to be the snitch, or you don't want people to think you're a whiner, or whatever your reason is, or maybe you're even scared of, whether your fear is justified or not, you're scared of reprisal. That doesn't create the legal duty, okay? Please don't share this complaint with so-and-so. I'm worried that they might TP my house or egg my house or whatever, okay? It doesn't create a legal obligation, okay? Reasonableness is not the same as legal obligation. It might be unreasonable for a board, if the complaining party says, look, I'm worried about retaliation. I'm worried about them keying my car or popping my tires, or
especially when there's a health and safety issue or a history that would justify.
I'm worried about that. Yep. I'm worried.
Yep.
Please don't share it. There might be a moral obligation on the part of the board. There might be it might be unreasonable for the board to not honor that confidentiality, but it is not illegal for the board to disregard the request for confidentiality. That's the point. Now, in our scenario one, we had a real case. This person complained in writing that and this person had a history of making complaints against this neighbor and every neighbor that had ever lived at that house. This person had only owned the house for 8 months, et cetera, at the time that this email was sent. The previous owner had the same problems with this particular complainer. So this complainer had a history of being a complainer. Had made multiple accusations of violations of this person's lights were in violation, or the height of the hedges, the height of their wall, the work that they had done that raised the elevation on their side of the yard that made the wall seem shorter, all accused of being in violation of the governing documents, all of which the board looked at and rejected and said, this person's not in violation, had actually okayed. Everything that was done in this person's yard was actually approved by the HOA in submitted plans. In other words, this neighbor was just wrong. On this particular occasion, though, this person complained that this dog had somehow jumped the fence in the middle of the night, and they had gone out to let their little dog out, and their dog was in their yard. And it's a big dog. It was a big dog, and they were very scared. This person submitted a picture snip from their video camera. That's going to be important later, okay? Then this person complained that they were very worried because this dog had been trained to attack. Now, for those of you who listen to my show, you know that I have Belgian Malinois and that my dogs are trained protection dogs. They used to compete in Mondio Ring, which is a very it's a very well-known sport in Europe. And it is the top echelon sport for dogs that are trained much better than police dogs. But they were trained for protection dogs, okay? My dogs are trained to do that. This person's German Shepherds were not at all. This neighbor, this complainant was just wrong. But anyway, complained about that, was saying that since it was so obvious this dog could come into their yard, he was very worried about his safety and the safety of his family. Then he went on to discuss what happened a couple of days earlier. He said, the other day, I was working at my wall and this dog came running out, charged the wall multiple times. How would you know if he was bending down, working on the plants, which is what he was talking about, working on the plants of the wall? How would he know the dog was charging the wall? We don't know. But at some point, he must have stood up because he was now watching the dog put his paws up on the wall. This man took out pepper spray and sprayed this dog directly in the eye. Just full on. Dog was a friendly dog. Was not expecting that. Injured this dog, okay? As it turns out, anybody looking at the picture of the dog in the video would have seen immediately it's a completely different breed. It's not even a German Shepherd. It is a different breed. It is a different color. The dog in the picture was pure black. This dog had black in it, but was not pure black. There was lots of brown. Our client never lets their dogs hang out in the yard for more than a few minutes to do business. This dog's always inside. So they were let out to go to the bathroom and they come back in. So they might be out 5 or 10 minutes unless our client's out there with them, which obviously wasn't the case here. So his accusations about the dog just being allowed to sit out there and bark forever, that doesn't happen. The dogs never bark for more than a few minutes at a time. And they only bark if there's a reason. Like, for example, you're standing staring at him over the wall. We believe, just based on the facts from this guy's letter, we believe that he was antagonizing the dog. But either way, the fact that this dog, no reasonable person could have inferred that this dog was the dog that was in his yard in the middle of the night. By the way, the dogs are never out at night. They sleep inside the house with our client. So dogs are never out. So he was wrong about that. And this dog never for a minute made it, acted like it was about to leap over. It just didn't do it. There was no reasonable basis to believe it. So the attack on this dog, we believe, constitutes a crime under the Penal Code 597, and we are pursuing legal action at this time. So I won't go further into details. Needless to say, that is scenario one. And this request for confidentiality was disregarded by the board. The board looked into the reason we know some of these facts is the board looked into it and shared them with the homeowner. And part of their investigation, the homeowner, our client, shared it with us. Okay. I then reached out and spoke with the board. Very friendly conversation with board members, and I got the same story.
Well, duty to make an inquiry, and their efforts to do so would be impeded if they were not able to.
Exactly.
Right? Muzzled in terms of, no pun intended, in terms of.
I get the pun.
Right? That said, also, if they had failed to act, then the same complainant would arguably take the position saying, like, well, you were remiss in not pursuing this and investigating it.
And that's why this person worded things in that letter. He was setting up the board to do this because he's had lots of, like I said, there's a past with the board, and it's always him being wrong. Now, so that's scenario one. No requirement for confidentiality for the reasons we talked about 5 minutes ago, okay? That doesn't mean board members are allowed to act vindictively or recklessly. So obviously, board members should not disclose stuff, even if not required to keep confidential. There shouldn't be disclosure if the intent is to harass, embarrass, or humiliate the complainer, okay? Nor should complaints ever be used as retaliation purpose of the complainer, or to disclose any information which might legally cause defamation or might constitute defamation, okay? Now, and the reason for that is because some of those concerns start to creep into, okay, it might not be statutorily required for confidentiality, but there might be fiduciary obligations. And now we're creeping toward scenario two, which is the quote I read at the beginning from the YouTube listener. That comment is scenario 2. So let's go into detail on scenario 2. That's the email alleging management misconduct, okay? If you'll remember from the beginning of the show, the second scenario is the question that we read at the beginning from the YouTube listener. And if you'll recall, that homeowner privately contacted a director to raise concerns about actual financial mismanagement, possibly embezzlement on the part of the manager or management company, with documentary evidence as to why he was going in that direction. Okay? The director forwarded that email and the attachment directly to the manager being accused. Now, it would have been appropriate and required for that director to forward it to the other directors. But since the manager was the target or the one being accused of financial mismanagement, this director sending it to that manager was, in my opinion, a breach of the law. Not because confidentiality was required in that type of communication being kept from the manager, because we just talked about the fact that confidentiality doesn't exist without statutory confidentiality. But it was, in this circumstance, under these facts, a breach of fiduciary duty.
Unreasonable
Activity that could hurt, and we're going to explain why. So while there's no statute that required that director to keep that communication confidential, directors owe fiduciary duties to the HOA, not to individual members, but to the HOA as a whole. Okay? So let's talk about that fiduciary judgment or misjudgment on the part of the director and why he was required to keep this confidential, but not because confidentiality was required, but because a fiduciary duty required it to be kept confidential. And the problem here is not that this director violated his legal duty to keep email confidential as a personal matter. It's because there's no such duty, right? We've talked about that. The problem here is how the director handled a good faith allegation of financial misconduct, serious financial misconduct, by the way, and whether that handling reflected a breach of reasonable due diligence on the part of that director and the other directors once they became aware, right? If their communicating it to the director was itself a breach of their obligation to conduct reasonable due diligence into legitimate allegations under Corporations Code 7231. We have done an episode on 7231 and the obligations that accompany that. And so if you want, you can click on that above. When a homeowner provides documents, like our YouTube complainant did, right, and raises a concern about potential embezzlement or financial misconduct, kickbacks, etc., okay, a director's obligation is to ensure that the concern is handled responsibly and in the HOA's best interest. In other words, the directors have to act in good faith in the best interest of the HOA, 7231, Corporations Code, okay? And that typically means elevating the issue to the board as a whole, and if it's appropriate, involving auditors or accountants.
Counsel.
Or all of the above.
Exactly.
Okay? What the director shouldn't do reflexively is forward that complaint to the very person being accused of the wrongdoing. Because among other things, that opens up the beginning of how to bury evidence. Before an investigation has been done, how can they bury evidence or hide the truth?
And under those facts, I mean, it sounds like they also failed to present it to the rest of the board and to deliberate with them at minimum.
Before
and they
acting.
Just jumped, the gun, acted
Very
hastily,
stupidly.
unilateral action.
That's right.
Which is also arguably running afoul of the Open Meetings Act.
Well, let's even go further. It's that kind of conduct by that director who did something very dumb raises a lot of red flags. Red flag number one, doing that, and I just hinted at this a second ago, can compromise a meaningful investigation before it even starts.
Yeah.
Can you think of another one of those? How about whistleblowing? and chilling. What
I
about
mean,
that?
yeah, I mean, yeah. I mean, you telegraphed it just now. It has a chilling effect because once you do that, the community as a whole will arguably and foreseeably lose trust in the process, and they'll say, okay, well, what's the point of bringing these in a confidential context
If I'm going to be
outed or shamed or
outed by a manager who
Right.
I know is guilty because I've seen evidence, and now this guy's out for me.
And then almost with certainty that there's going to be some kind of a blowback effect in
100%.
in the sense that they will act in reprisal.
Or even if not, the chance of that retaliation happening causes a lot of stress, and it's enough for other homeowners to go, I'm not going to do that.
Yeah.
Or they'll do it, but they'll do it anonymously, which leads to a little bit more of a lack of credibility. When something's done anonymously, it's not always as credible. And so either way, it will jeopardize future investigations.
Agreed.
But as I said, the first one, it actually hinders an investigation. It fosters destruction of evidence.
Yeah.
It can expose the HOA to retaliation claims or breakdowns in governance, okay? It can create the appearance that management's being protected rather than scrutinized. The only reason a director who receives a complaint like this would share it immediately with that manager is if that director and the manager are in cahoots.
Yeah.
I can't think of a legitimate reason why the first thing that director would do is share it with the manager being accused of embezzlement and kickbacks, other than that director and the manager in conspiracy with each other. Can you think of a legitimate reason why that would be his first thought?
That is not a reasonable inquiry or act to take.
Doesn't make sense.
And it's very dismissive of the complaint and the concerns you've received as a director.
But it doesn't make sense.
It makes no sense.
Can you answer this? Can you think of a legitimate reason why a director who receives that kind of specific complaint and documentation along with it, the first thing they would do was forward it to the manager being accused as opposed to the rest of the board? Other than a nefarious connection, what legitimate reason would a director have to make that their first thing to do? I can't think of one.
I can. I was trying to twist myself into a pretzel to try to come up with one. If there's a pre-existing investigation, but even then...
Doesn't exist. There was no pre-existing investigation.
No.
This was the complaint.
Yeah.
He was the only one that received it, and the first thing he did was forward it to the manager. He didn't say, I should share it with my directors. They meet and talk about it, and then they said, let's share it with the manager. That would be a little more supportable. Okay, no. He sent it to the manager, then forwarded it separately to the director. Okay? Bottom line, guys, there's a broad governance issue in a case like this. Sharing a homeowner's allegations directly with the person being accused, especially when there is credibility to the accusation, and it's a serious one. Financial impropriety is very serious. Without first vetting whether that's a good idea through the attorney representing the HOA or at least the rest of the board. It undermines every internal control a board might put in place to handle things like this, or weaken the HOA's ability to even evaluate serious financial improprieties objectively. You can't objectively handle it when you've got the person being accused playing defense already and coming to you and challenging it before you've even had a chance to discuss it amongst your fellow directors. It's insane.
Yeah.
Okay? At the point where allegations of financial impropriety or misconduct are dismissed, redirected, or turned into a public relations campaign like it did in this case, and it allows management to publicly start defending itself before homeowners even know what's going on, right? It stops being a simple governance obligation and just it becomes this incestuous, non-helpful.
And by the way, one
whatever,
point, and I believe you alluded to this, but it could also lead to destruction of key evidence if they have advance notice.
I said that,
and that's
right.
a huge part of it. Yeah,
I said that earlier.
Yeah.
You just you give them time to start bearing evidence. Exactly.
Yeah.
The key takeaway is this in scenario 2. A director is not required to keep a member's complaint confidential simply because the member asked, but the director is required to exercise reasonable judgment and good faith.
Yep.
Corporations Code 7231. Okay. Reasonableness, exercise reasonable judgment and good faith in deciding in a given scenario how serious the allegations are and whether or not sharing it could breach their fiduciary duty to the HOA as a whole. In scenario 2, we believe it was a clear breach of fiduciary duty. Now, those kinds of cases, the non-statutory ones that are fit scenario 1, the 3 kinds that we gave you before, These kinds are very case dependent or fact dependent, case by case.
Right.
One case might be, the other case might not be. The one that Sam gave an example of at the beginning that I said might cause some confusion would be one where it doesn't even, doesn't extend to that. That would be, under those circumstances, permissible. But under this one, I think it's clear it crossed over into fiduciary breach.
100%.
Just by the nature of the allegations. Folks, boards are required to keep certain things confidential as a matter of law. We talked about that. Boards are also required to keep other things confidential, not because a law says they have to keep that type of complaint confidential, but because it crosses over into it's unreasonable if you don't, or it extends into a breach of fiduciary duty. And that was scenario 2, okay? Boards have to exercise at all times in everything they do when they're acting in their capacities as directors. They must act reasonably, and they must act in good faith for the benefit of the HOA as a whole, not for their own benefit, like they're friends with the manager and they have a personal relationship. That's them not acting in the benefit as a whole. Hey, I want to warn you, this is coming down the pike. No, that's them acting in their personal benefit. That's a fiduciary breach, okay? If your HOA is mishandling these kinds of complaints or violating statutory confidentiality obligations, that is a serious issue. And at that point, document everything, keep everything, make everything in writing, but that's when you probably want to call us at MBK Chapman, because we're experts at holding your HOA accountable for its obligations to you, okay? If you like this episode, please hit the like button. And if you haven't already done so, it really is helpful if you guys can subscribe to our channel. If you want to leave a comment or ask a question, please do so. As you can see, I do answer a lot of those questions. Until next time, folks, have a wonderful day.